Okay, let's get going. We have a lot to cover today. My name is Kimball Parker. I'm the CEO of 650. And for those of you that are hearing about 650 for the first time, we're the technology arm of the law firm Wilson Sonsini. So we're their technology subsidiary. And just a little background on Wilson Sonsini. They're one of the best law firms in the world. They are the leading technology law firm in the world. So they helped found Apple and Google and brought them public. Same with Twitter, Lyft, SpaceX. The best, most exciting companies in the world use Wilson Sonsini. I just want to back up and talk about the law briefly before we jump in. You know, in order to comply with certain laws, businesses need a lot of paperwork, lots and lots of paperwork. They need policies, procedures, notices, contracts, and those documents need to say the right things. And if not, there can be serious consequences. And that's especially the case with privacy law. And so what lawyers do, you know, one way to look at what lawyers do is that they make sure that the paperwork says all the right things. And, you know, lawyers write documents all day. That's what I did as a lawyer. And so what we've done here at 650 is we've worked with Wilson Sonsini to teach a computer to write legal documents like a lawyer with all the right words. And so our products are like TurboTax, but with the best lawyers in the world behind it, helping. And so, you know, the idea is to make that legal paperwork more affordable and more convenient so that any company or person can afford it and can afford the same level of expertise that's going into, let's say, a client like Google. And so our systems can help companies, our products can help companies generate over 100 different legal documents. And actually, we're hoping to double that within the next year. So that's a little bit about 650. Today, we're going to be talking about the new privacy law in China. So on Friday, August 20th, less than 2 weeks ago, the top legislative body in China, called the Standing Committee of the National People's Congress, passed a new privacy law. It came almost completely out of nowhere. And so without much warning for a law of this size. Now, the law is called the Personal Information Protection Act, or PIPL. It's similar to the GDPR, which is the law, the governing privacy law in Europe that was passed a few years ago. And on this webinar, we're going to talk about how those laws are similar and how they're different. Now, here's the scary part about this new Chinese privacy law. It goes into effect on November 1st, 2021. So in 2 months, almost exactly 2 months from today. So this is a big change, you know, for some of the big landmark privacy laws like the GDPR and in Europe and let's say California's privacy law, the CCPA. Those laws gave companies a year and a half or 2 years to comply for the GDPR. China is giving companies 2 months. That is a lightning fast turnaround for businesses. And it's you know, businesses have an uphill battle here. So there are a lot of things that companies need to do to comply, and we're going to talk about those today. The law, and this is going to come up, but the law roughly, you know, applies to any company that has employees in China that does business in China. And you know, there's some kind of fringe cases which we may cover today. But you know, if you have employees in China or you sell goods or services in China, you very likely have to comply. So we have been working nonstop since the law passed to understand what companies need to do to comply, and specifically what documents that those companies need, so that we can, you know, automate those and help companies help companies do what they need to do. So what we've done is we've read the law, we drafted all the policies, website notices, contracts, and cost benefit analyses or impact assessments that companies needed. We then sent that documentation over to Wilson Sonsini's privacy group, which is one of the best privacy groups in the world. They've reviewed it, and then they sent it over to who we consider to be the top privacy experts in China. And then we have now taken those documents and we've automated them like TurboTax. And so anyway, the result we think is the best set of compliance documents for the PIPL on the market. So anyway, why am I telling you this? It's because you're going to hear from two of the people that built that tool. So it's not a stretch to say that these are two of the people in the nation who know this law the best. So the first is Marie Colbeth. She graduated near the top of her class from one of the best law schools in the nation. She clerked for a federal circuit court judge in the South. For those of you who are a little unfamiliar with the structure of the legal system here, the circuit court is right below the U.S. Supreme Court. So she's worked in private practice. She was a law professor at BYU, which is where we poached her from. And it was one of the best decisions we've made. It's really not an exaggeration to say that Marie is one of the top privacy experts in the nation. So be prepared to be impressed there. The second person you're going to hear from is Austin Smith. Just like Marie, graduated near the top of his class at one of the best law schools in the nation, the University of Virginia. Austin also clerked for a federal court judge. He has worked for some of the biggest, most important privacy law firms in the nation, and which is where we poached him away from. Again, incredible, a decision on our part to get Austin. He's been invaluable for us, especially reacting quickly to these laws. And just like Marie, he's one of the, he's arguably one of the top people who especially know this Chinese privacy law. So we are bringing in our top guns here. So before we get started, just two little notes. We are seeing very high demand for this automated Chinese, this automated product for the new Chinese privacy law. If you want to get on the schedule to see the tool, you can visit 650.com/China. So 650.com/China. We're looking to launch the product on September 8th. So that's the last thing I'm going to say about our product. You can get in the queue now, 650.com/China. Okay, number two, if you have questions, please put them in the Q&A button below, not in the chat. It's a little easier for us to kind of sort through those in the Q&A. So if you could do that, that would be great. So without any further ado, enough from me. Let's turn the time over to our privacy experts. This should be a meaty 50 minutes you have in store here. So Marie and Austin, take it away.
Thanks, Kimball. And I'm really excited to have Austin here with us today. If any of you were on our last webinar about China's PIPL, it was me for 50 minutes, and I don't think that was fun for anybody. So we're going to dive in today and focus really specifically on the ways that PIPL is similar to and different from the GDPR. And as you can see here, we have a few different things that we want to address. We're going to start off by going over the coverage of the two different laws, both in terms of territorial scope and the data that they cover. We're going to talk about individual rights under these laws, and then we'll talk about, Kimball mentioned a little bit about the importance of documentation when complying with privacy laws, so we're going to focus on that. And then we'll also talk about liability and enforcement. So, what potential fines could you be looking at? What other enforcement mechanisms has China put in place? So this is a fairly broad overview. And just to sort of set the stage, one thing to keep in mind is that, these laws are in some ways really similar, which I think has surprised some of us as we've seen China coming out with a fairly robust privacy law, but there's also differences. And in some ways, the Chinese law is, requires more. And in some ways, it certainly provides less protection in some ways. So that you get a little bit of both, as we'll be talking about today. So with that, we're going to start off by talking about the scope of the laws. And you'll see throughout the presentation, we tend to sort of just use the graphics to help you know which one we're talking about. So on this slide, we've got PIPL and GDPR, but you may just see a graphic on some of the other slides. So with China's law, one of the most important things to recognize is that if you're handling information inside of China, personal information about people who are in China and you are inside of China, the PIPL covers that, no questions. Similar to the GDPR when you're in Europe. when you start talking about processing data outside of the territory is when it gets a little bit more nuanced, and you have to look at what's going on specifically with your data transfers. So if you're handling the personal information of people who are inside of China's borders, while you, and I say you, it could be your organization, or if you have a processor in place, if they're handling the data outside of China, then the law still applies. If the purpose of that handling is to provide goods or services. So as Kimball mentioned, if you're selling goods in China, it's being purchased by persons in China, that data that's associated with those sales, that's all covered. If you're using it to analyze or assess the activities of people in China, and so this is where we really do see like a really close similarity to the GDPR. So with the GDPR, if you're processing the data of people inside of the EU, and that processing is happening outside of the EU, if you're offering goods or services in the EU for those people whose data you're handling, or if you're monitoring their behavior, then it's covered. So we see it's really similar. It's a little bit different in terms of the language, but again, we're also working with translations. So where the words are pretty close, I imagine that we'll see fairly similar exercise of jurisdiction. One thing that the Chinese law has that's sort of like, I'm from Louisiana, we'd call that this lanyap, a little something extra, is in addition to the two circumstances that are really like the EU circumstances, the Chinese law also will apply in, quote, other circumstances provided in laws or administrative regulations. And that's sort of a catch-all that we don't know yet how that will be interpreted. So there's the potential for, if you think like, oh, I see a potential loophole, the way we're processing this, or the reason that we're processing it, maybe, points 1 and 2 don't apply to us. Point 3 might, as we see how China decides to interpret that. So, but again, like if you're processing the data of persons inside of China, whether you're inside of China or out, most likely it applies to you. And so what information is included in that? So, when we say personal data or personal information, what does that mean in this new law? And so I've put up for you the exact definitions pulled out of both laws on the slide, just so you can reference it. And I've bolded the things that you see that are directly the same. And although the EU law looks a lot longer and a lot more detailed, the truth is that because of some of the terminology used, I do think that the definitions are essentially the same in the way that they'll be interpreted. So when we look at personal information under the Chinese law, it says it's all kinds of information recorded by electronic or other means related to identified or identifiable natural persons. And that language, if you look, it's really closely reflected in the GDPR, which is, information related to an identified or identifiable natural person. So that's, essentially exactly the same. The EU does add this language that says an identified natural person is, so they specify that definition and say that it's someone who can be identified directly or indirectly. So the Chinese law doesn't have that additional language, but they don't have a specific definition for an identified or identifiable person. So I actually think we'll see them looking to the GDPR to interpret, what does this mean? And then we have some examples given in the GDPR version, whereas the China version did not give examples specifically. But one thing that they did do is they carved out some information. So in the PIPL, China has carved out information that has been anonymized. So when you first collect the data and it's not anonymized, it's covered. But then after you put it through some process that anonymizes it, then the data would be considered exempt from coverage of this law. So some data will start off as being covered and then become non-covered data. And that I mean is not that unusual. We see that happening, once it's been anonymized, it's no longer personal data, but just a very specific carve out there for China. Now, in terms of what information is covered, there's also a few other like key definitions that we get. And one of those is regarding sensitive information. And if you're very familiar with the GDPR, they don't use the word sensitive information. They call it special category information. But China calls it sensitive information, which if you deal in California data, that's what they call it. That's what Virginia calls it in their new law. And so we do see some similarities in what's considered sensitive in both jurisdictions. However, in some ways, the Chinese law is definitely more broad. So for example, and again, I've bolded the ones that you see under the China list that match ones that you see on the EU list, which is on the right-hand side of your screen. So essentially, while they've given some specific examples, the definitions themselves of sensitive information in China, it's information that if it were leaked or used illegally, it could cause harm to the dignity of persons, or, and this is an interesting part, to the security of their person or property. And you contrast that with the EU, where it's the specific list of information. It's not sort of a broad definition. They specifically say it's anything that's on this list. And so, you know, political or ethnic information, political opinion information, religious or philosophical beliefs, trade union membership, genetic or biometric data that's used for the purpose of identifying, or can be used for the purpose of identifying a person, health data, sex life or sexual orientation data. That list is limited. If it's on the list, it's included, but in special category data, but if it's not included. Whereas China's law, you know, people could make arguments about what's included beyond what's on their list. And so, for example, we have on the list, just like the EU, the biometric data, religious belief data, and medical data. We have some things that aren't on the EU's list. So, you know, your financial account information is considered sensitive information. And actually, if you're familiar with California privacy law, that's coming in the CPRA. That's sensitive information under the CPRA in California. Individual location tracking, which they haven't defined. If we do look to other jurisdictions, California considers, you know, if it's within a third of a mile, then it is this, you know, type of data. And then any personal information of minors who are under the age of 14. So that's a really large category, but this isn't it in China. So if an argument can be made that the data that you're dealing in could somehow harm somebody's actual person, so physical harm, or their property, which is one that we just really haven't seen before, then it could, you know, be included into this category. So we haven't seen any examples yet. We'll have to stay tuned for that one, but definitely a difference that we see there. And we'll see the property piece come up again in China. So that is something that they're thinking about that hasn't necessarily been addressed in the GDPR in the same way. And so that's the data that's covered, including our sensitive information data, which has special restrictions placed on the handling. And in China, just so you know, that special restriction is you can't handle it without meeting some additional procedural requirements. Just like in the EU, you can't handle it unless you identify your lawful basis under Article 6 and Article 9. So both of them require a higher bar before you can do anything with that data. So actions generally that are covered. So we're moving beyond sensitive information. Now we're talking about all information. This is, again, a place where we see some differences in the language being used, but really what we think are essentially the same activities are intended to be covered. So in China, they're using the word handling for what we typically in the GDPR call processing. So handling includes collection, storage, use, processing, transmission, provision of, disclosure of, deletion of data, but they also threw in the word etc. So that sort of tells you, like, they're really trying to encapsulate everything you could potentially be doing with this personal information that's covered by the law. And I really do think that is exactly what they were attempting to do with the definition of processing in the GDPR. You see the bolded words where you have the same inclusions, but even the things that aren't a direct match, they're really getting at processing of data, which is directly included in the Chinese law. So, organization of data, structuring of data, altering data, retrieving it, consulting it, all of those things. I would say China will say, yes, that's covered too when we say processing. Or if not when we say processing, we said et cetera, so that we could, figure out exactly what we intended to include. So again, I don't think if you're complying with the GDPR and you're trying to decide, well, what do we need to do to comply in China? The answer is any activity that you consider to be covered by the GDPR. If you're doing that same activity with the data of individuals in China, you should probably just consider that activity to be covered. That's going to be the safest interpretation. And so if it's covered data coming out of a covered jurisdiction, the activity that you're engaging in is covered by the law, what do you have to do? And the answer in both jurisdictions is that you need a legal basis for processing that data before you can process it. So I've made a quick list here. If you're familiar with GDPR's legal bases for processing, they include consent, performance of a contract, legitimate interest of the business. And that's the first one where that's not included in the Chinese law. So far they match, but legitimate interest is not a match. To fulfill a legal requirement, that's a match. In the EU, in the public interest, so like the government interest, processing prong is not included in the Chinese law. Although the way the law is written, if the government wants to process data, it's going to be able to in China. So if you're a contractor for the Chinese government and you need to process something on their behalf, you're still going to be able to process it. That will be allowed, but it's not laid out specifically the same way. It's more of a loophole of what data is covered than it is a specific legal basis for processing the way that it is in the EU. And then some additional ones that constitute a legal basis in China that aren't a direct match with anything in Europe. For human resource management. So if you have, again, employees in China, for public health incidents. So this is interesting, and I think it's reflective of the time when the law was written, to be able to process information for public health reasons. And, in the EU, they've been able to process that data under the GDPR by basing it on other legal bases, but it's its own specific legal basis in the Chinese law. And then again, I mentioned before, property, to protect property in an emergency. So if data needs to be processed in some way in order to preserve property, that would be sort of an exigent circumstance where it could be processed without meeting some other legal basis, whereas maybe you would normally need consent. And in China, consent is the legal basis that they seem to rely upon the most. So I did see somebody did ask in the chat what they're trying to get at with harm to the dignity of persons, their security of their person or property, which was the last slide. When we're talking about harm to the dignity of, what is probably being addressed is what we see in the GDPR as, not just reputational harm, which is what I think some people think of when they read that terminology, but also, for example, harm to their ability to get a job, harm to their ability to get housing, or in some way harm what might be more broadly construed and in GDPR is construed in terms of human rights. It's not construed that way in the Chinese law, but that is probably what they're getting at. But in addition, with the security of property, again, the intention to protect property is sort of driven home in two different ways, both in terms of what a legal basis for processing might be, and also what might be construed as sensitive information. And so I think we'll see, and this is something common throughout this law, we're going to see some more clarity come from the Cyberspace Authority of China, which is the overarching regulatory body that has responsibility for this law. And in a lot of ways where we see maybe some gaps and definitions and things like that in the PIPL as it's currently written, there's indications that authority is supposed to come in and do further planning and further explaining and set up mechanisms for it to be carried out. So I think we will see some more explanation on that one. But these are legal bases that you could process data under. You need at least one of them. And in addition to that, I think a lot of people on the call today are probably looking at this from a perspective where they won't necessarily be processing data solely inside of China. They will be, bringing it outside to the location of wherever their corporate headquarters are, for example, whether that's the United States or Europe or India or wherever it might be. And so in regards to your legal bases, one thing to keep in mind is if you're going to handle information across borders, you have to meet special rules. So it's not just that you have a legal basis. You also need to, if we could advance to the next slide, you also need to sorry, I said that right when you were hitting it. So you were actually landing on the right one. So you have to pass a security assessment that would be administered by that authority I just mentioned, the Cyberspace Administration of China. We haven't seen what those assessments will look like yet, so it's not really possible for you to pass it yet. You can undergo a personal information protection certification from a specialized body, which would need to be authorized by the Cyberspace Administration. Or you would need to enter into a contract with the recipient side. So you're, whoever's receiving the data outside of China and whoever's sending it from China to outside would have to enter into a contract. And that language needs to match something that's formulated by, again, the Cyberspace Administration. And so I think that's the thing that most people are waiting for that we don't have yet. So this would be equivalent to the GDPR's standard contractual clauses, which, if you adopt those in contracts between parties, and now if we also are adopting them and sending the information into a country that's safe enough, then you can send data outside of the EU, with that being what's called your transfer mechanism, the standard contractual clauses. So think of these three things as your potential transfer mechanisms for Chinese data. The problem being that right now we're still in a wait and see place for all of them. So on November 1st, technically transferring data outside of China without being able to meet one of these transfer mechanisms, personal data that's covered by the law, would be a violation of PIPL. That being said, and although we do anticipate strong regulatory supervision, I personally don't think that they'll start issuing fines on day one for the majority of companies, because the goal of China here doesn't seem to be to impede business. It seems to be to make themselves a more active participant in international privacy law, to protect their citizens' data. They've had a lot of problems with consumer fraud happening inside of China. So that seems to be more their goal. And so I anticipate we'll either see the standard clauses come out soon, or that an easy way to access and then pass the security assessment will be publicized. So those are going to be your cross-border transfer mechanisms once they are approved. And so talking about this, sending data out from inside China to outside China, who's who? I think in privacy land, we tend to use words that mean something to us if we've been in the privacy space, that can be really confusing to newcomers to the space, but also that are different across different jurisdictions. And so, we tend to use GDPR language and call people who own the data your controllers. That's, the party that's making decisions about how the data is going to be processed, what data is going to be collected, and all those things. And they have to meet heightened requirements under the GDPR. So their processors who handle data on their behalf also have rules and regulations they have to comply with. But they're below the controller in terms of the authority that they have, and in terms of, therefore, their legal responsibilities that they have. Really similar situation in China, but different language. So the PIPL is calling what we might consider to be controllers personal information handling entities. And so, again, really similar to controllers in that the way they've been defined is that they are the party that independently determines the method and means of handling of the data. And then, again, similar to GDPR, if they're entrusting that data to another party, that party is called the entrusted person, which would essentially be equivalent to a processor in the GDPR. And just like in the GDPR, they have to enter into data processing agreements in order for that transfer to be legal, where it goes from a controller to a processor. There has to be a time limit on how long the processor can handle the data. Sorry, the entrusted person can handle the data. There's requirements in terms of like laying out which categories of personal information are going to be entrusted, how the entrusted person will handle it, what their duties are. And then, similar again to what we see in the GDPR, an entrusted person cannot further entrust the data to another party without permission from the handling entity. And that is reflected, we also see in the GDPR, where, you know, a processor can't engage sub-processors without permission. One of the main differences here is that in the GDPR, it's spelled out and, you know, how someone could get permission. You know, you can either have generalized permission process put in place in the DPA, or you could have to get specific permission each time you get a new sub-processor. China hasn't laid it out in that level of specificity yet. So again, that's something that we anticipate the Cyberspace Administration might give us further guidance on. But for the time being, again, China was really looking quite a bit at GDPR when they drafted this law. And so for now, probably the best interpretation is that it would be the same way, either generalized authorization where there's a procedure put in place where you can get permission for a further entrusted person, or the requirement, and again, these would both be in the contract, that you'd have to get specific permission for each new entrusted person. So very, very similar, just a little bit different in terms of the language being used here. A little bit more on those entrusted persons, because I'm sure a lot of people on the call right now are in fact going to be in a situation where they're probably the entrusted person. So this just sort of outlines what needs to go into your contracts. I'm not going to read the slide to you. But I think the main thing to keep in mind here is that, you know, both parties have duties. One of the important things to make sure you're putting into your contracts is that the entrusted person cannot handle the data in any way or for any purposes not specifically allowed in the agreement. And again, that's GDPR language, that's CCPA language. This is the most important thing from a data privacy perspective, that, you know, those entrusted persons or processors can't use the data for their own means, because that would essentially void the notice, which Austin's going to talk about in a minute, that was given to the individuals whose data is being processed. So that sort of brings us to the individuals and what are their rights under this law. So we've been talking about all these restrictions and things, you know, what's covered, what's not covered. At the end of the day, if it's covered, you know, what rights attach to that information? And so I think this is actually really exciting to think about, because I checked yesterday, and China makes up for about 18% of the world's population. So 18% of the world's population has received new data privacy rights, and that's huge. So jurisdictionally, this is the largest number of people to ever be vested with privacy rights at one time that we've ever seen so far. And so, you know, thinking about what does it mean, and, you know, what are those rights? So we've sort of laid it out. You have China on the left of your screen and Europe on the right, the EU, I should say. Both laws give the right to information. And so you've got the right to notice about what's happening with your data. You have the right to access that data. You have the right to correct it or rectify it if it's incorrect. So, you know, once you've accessed your data, if you looked and you're like, oh my gosh, they have this wrong, I want it fixed. Individuals will have that right. They also have the right to request erasure of their data in both jurisdictions, to object to and have the processing of their data restricted in certain ways, to have their data ported. Now in China, they've added a stipulation there that you can only have your data ported if where you're sending it to satisfies some conditions stipulated by the Cyberspace Authority. So essentially, you can port your data, but if you're trying to port it somewhere that's unsafe, it's probably not going to be something that a company has to comply with. So like if I wanted my data ported and I want it ported to a third country, and, you know, you as the company sending that data to the third country would violate the PIPL, that's a problem. So in that situation, you'd probably look at just sending it to the user directly, or some other workaround. Both jurisdictions spend a fair amount of time talking about the right not to be subjected to automated decision making. And so this one I think is really interesting because you've got you know, a lot of new technologies, and we've seen the use of a lot of new technologies in China. So if it's making automated decisions without any human intervention, it is something somebody can opt out of. So you can also withdraw your consent and lodge a complaint. And that I think is the biggest one, lodging a complaint, because they can bring the regulator bring you to the regulator's attention.
All right. Thank you, Marie. So I am going to mainly go over for the rest of the presentation the required documents that you're going to need under the PIPL. This is kind of when the rubber hits the road, what do you need to actually have in place? Kind of as Kimball was saying at the beginning, there's a lot of paperwork, a lot of P's and Q's to keep in mind. The general category of documents are going to be notice to data subjects, contracts with entrusted parties, which Marie's gone into some detail on, certain internal data handling policies, and personal information protection assessments. So that's going to be a corollary of the GDPR's data protection impact assessments. I've listed here, not going to read off the most relevant articles in the PIPL that talk about these documents. And I will quickly note that the notice in some situations is going to need to include contact information for certain recipients of the personal information. So if you share personal information in some circumstances that we'll go into, you'll need to actually share the specific organizations that you're sharing it with, not just categories of people. So that potentially could be kind of a separate document from the notice, which we'll talk a bit about, and also the internal policies. You're going to need the security incident response plan, basically for data breaches. What are you going to do? So that could potentially be a separate policy as well, but these are sort of the high level ones. So we can jump first to the notice that's required. This is kind of the privacy policy, your website, link, what you need to tell data subjects about before you can handle their data. So here we have some compare and contrast what China requires, what the EU requires. You'll see that most of them are the same. As Marie mentioned earlier, there is not a legitimate interest basis for processing information. Under the EU, that is a possibility, and if you're using that, you need to disclose it to data subjects. But in China, the legitimate interest basis for handling personal information doesn't exist. The other thing to note here is that on recipients of personal information, the EU only requires the categories of businesses you're sharing it with. It could be, like our marketing partners or, cloud storage vendors, things like that. For the PIPL, there are two categories of disclosures that you need to specifically provide contact information for in the name of the other organizations that you're sharing it with. The main one is if you're sharing information with other personal information handlers, aka in GDPR terms, other controllers. So if you give personal information to another organization for them to do whatever they want with for their business purposes, that type of sharing, the PIPL requires that you tell data subjects, here's who we're sharing it with. It's, company ABC, their website is this, here's their email address, that kind of thing. It's not just we're sharing it with our marketing partners. And similarly, for overseas transfers, the GDPR just generally says, we are going to transfer data to other jurisdictions that may not have the same privacy protections as the EU does, but we're using this general transfer mechanism, and we're taking these steps to make sure your data remains secure. So you just need to tell data subjects that that is happening generally. Under the PIPL, any recipients of the data outside of China that you're sharing it with, again, you need to provide their company name, contact information. So that one is either for personal information handlers, controllers outside the country, or processors outside the country. So those two, again, could be potentially different documents. If you don't want to list all those people in your privacy notice itself, you might say, hey, here's a link to the current list of people we're sharing this information with, or sending it overseas to. As Marie mentioned as well, the PIPL doesn't specifically require you to tell data subjects how they can complain to the CIC or other government agency. And the other thing that the PIPL goes into a little bit more is if you're collecting images or using facial recognition technology in public areas, you have to have clear signage about that so that people walking into the area generally will be aware. And there are definitely restrictions on how you can use that. And then the contracts with processors, or as the PIPL calls them, entrusted persons. These are largely going to be the same. Marie went into some detail, and these slides will be sent out. So if you want to go back to the previous slide about entrusted parties and what's required there, for the most part, these are pretty similar. And we can go back, sorry, to the processor slide. The one thing that might be slightly different is that the GDPR requires processors to allow for audits, and China says that personal information handlers or controllers will have to supervise the processor or entrusted person. So it's unclear if that means the exact same thing as audits, if it's something more that's required, but that is something to keep an eye on. Then the next category of documents that are required under both the GDPR and PIPL are internal policies. In certain situations, you're going to need certain documents. Under the GDPR, you have to have internal policies and documents in place that include things like we design our applications with privacy in mind. We try to make the default settings privacy protective, things like that, how we train employees, whether we need internal audits, things like that. We practice data minimization, etc. Internal audits specifically are only required under the GDPR if you have a data protection officer, although they might be useful other times as well. Under the PIPL, you will always need to have a policy in place that talks about when you're regularly and periodically conducting internal audits to make sure that your company is actually following what your policies say. The other two things to note about the PIPL, as I said before, you need a security incident response plan for data breaches. And perhaps the most interesting one is this independent oversight body that some companies will need. It's only for large companies that process a large amount of information as defined by the CAC, which hasn't been done yet, but we expect will be a relatively high number. So if you have a very big company that's processing a lot of Chinese people's information, in certain situations, you might actually have to establish an independent body to supervise how you're protecting personal information. We don't expect many of our customers will need that, but definitely something to keep in mind and to look out for if this number comes out, and it might be something that you run up against. And it also says companies whose business models are complex. So that is going to need a little more clarification as well, but that's the internal policies. The last set of required documents we want to talk a bit about are impact assessments. So again, the names are very similar: personal information protection impact assessment or data protection impact assessment. I did put the acronyms here because my one goal with the PIPL, I don't know if Marie and I can influence the pronunciation of PIPL to be that or PIPL, who knows, but I want the acronym for personal information protection impact assessments to be PAPAYA. I think that would be great. So if you have any influence, refer to them that way.
You make a strong case, Austin.
I know, right? I mean, got to have a little bit of levity in these things. For these impact assessments, when they're required, there's definitely some difference. automated processing sensitive personal information, you need them under GDPR or the PIPL. The GDPR also has things like systematic monitoring of public areas or large scale processing, and has just kind of a general catch-all. The PIPL doesn't have those last two, the public areas and large scale processing, but does say anytime you disclose personal information to any other entity, specifically even entrusted persons or processors, you need to do one of these impact assessments. We'll talk about what that includes, but also any international transfers you do. Again, whether to another personal information handler / controller or to a processor outside China. Anytime you do one of those international transfers, you need to do one of these assessments. So for many companies, they'll need to do more of these under the PIPL if they're subject to it than under the GDPR. So definitely something to make sure to look into. What does an impact assessment look like? Well, the GDPR provides a lot of details, description of what you're doing. If you have a legitimate interest, what it is. You need to determine if the processing under review is necessary, and if so, if it's proportional. You need to list risks to the data subjects. You need to list all the mitigation measures you're taking, like, oh, well, we're encrypting things, or we're keeping this, on a separate computer system that only a few people have access to, whatever those things are. And just kind of weigh all of these things and come to a conclusion. Yes, we think this is okay. If it's still dangerous, you might need to talk to a supervisory authority, etc. Under the PIPL, all they say is that you need to conduct an impact assessment in those situations. It doesn't say anything about what needs to be included. As Marie said, China was clearly generally looking at the GDPR when crafting their law. So as a first cut, until any more guidance is given, it sounds like using the GDPR factors would be a very good place to start. So something along those lines would be advisable, at least until the CAC or other Chinese government bodies give any more details about that. So I think this is one of the big differences between the PIPL and GDPR is anytime you use a vendor with Chinese people's information, you might need to be conducting an impact assessment. And I will also just give a quick plug for 650's data protection tools. You can go to 650.com/privacy to see, in addition to China, which we're going to be rolling out next week, we have GDPR specific documents that do these data protection impact assessments and things for CCPA, etc. These impact assessments are going to be a decent amount of paperwork, and whether you use us or some other process, it's definitely something that you're going to want to have a plan for and be able to streamline in one way or another. And now we'll end before we get to a few questions. Hopefully we have a minute. The last section is on how the PIPL will be enforced, everyone's favorite stick. So there are a number of similarities with the GDPR. Pretty big fines. 1 million yuan is, we pulled this up, $154,000 as of today's exchange rate. So pretty significant. These are for uncorrected violations. If the CAC or other government body reaches out and says, hey, this is in violation of the PIPL, and you don't fix it or can't fix it, these are the fines. One big thing to notice, though, is that in addition to your company receiving an administrative fine, it also provides for somewhat smaller fines against the people within your company who were directly responsible for the violations. So that is a little bit scary. Not just your company, but potentially individuals will be subject to fines. And for grave violations, which it doesn't go into much detail about what separates a grave violation from a garden variety one, The fine can be up to 50 million yuan, which is, I want to say, $7.7 million, and or 5% of annual revenue. The GDPR goes up to 4% of worldwide annual revenue. The PIPL doesn't specify whether it means worldwide annual revenue or just revenue in China, but it might be safe to assume that, again, it's similar to the GDPR. And again, there can be fines for individuals within the company that were responsible for the grave violation. And in that situation, even the CAC can order that whoever the manager or director who is responsible for the violation can no longer hold a high company position, at least for a certain period of time. So again, some kind of more personal targeted compliance sticks to look out for.
Might see some employees asking to renegotiate their employment contracts for some protections.
That's right. Indemnity might be an interesting issue. Yeah, that will definitely be something to keep an eye on. And then beyond the fines, there are a few other general enforcement powers that the PIPL gives to administrators. If we can go to the next slide. Again, or just ordering correction is the first step, and confiscating any unlawful income if you violated the PIPL and made a certain amount of money that they can point to from that. That could be something they could claw back. They can order suspension of your service, not being able to do business in China, or at least not be able to do the specific types of processing you were doing that for one reason or another violated the PIPL, and pay compensation in certain situations. It mentions criminal liability, doesn't give more detail. It looks like that's more of based on other laws. If you've committed a crime, just keep in mind you could also be liable for that criminal liability. And the GDPR goes into more detail on these things, but broadly are pretty similar. The GDPR also has a number of factors that supervisory authorities will weigh when giving a fine. The PIPL doesn't specifically list those factors, so it's unclear how the process will shake out, whether they give a $10,000 yuan fine or 100,000. I assume that they'll be weighing the types of things under the GDPR, but it's not a requirement like it is under the GDPR. So we have a few minutes left for questions and answers. I think we've gotten to everything in the Q&A, but Marie, if you have any other things that you've noticed that might be worth addressing to the entire webinar, jump in.
Yeah, I would just note, kind of going towards that, that last section that you were on, Austin, in terms of enforcement. If you're wondering how strong enforcement might be, the PIPL, while it was sort of like a surprise in a lot of ways, it comes on the heels of a new cybersecurity law in China that was just passed. And so we have seen like really strong regulatory action recently around these types of issues, although not privacy specific. And so a lot of the chatter, if you will, in the privacy world is that we are expecting to see strong enforcement coming out of China on this. It's just sort of a question of, who do we think they're going to focus on? Some of the indicators have been, you talked for a minute about the large platform providers. There's some expectation that might be where the initial focus is, but it's hard to predict, right? But we do think overall the enforcement will be strong. So for example, we've seen some varied enforcement of the GDPR across the EU, but it is being enforced across the EU. Whereas I think if people are on the call who've been dealing with enforcement of the CCPA in California, they've recognized that so far enforcement has been what I might term a little bit lax. And a lot of that was because of the expected changes coming, right? The formation of a new authority that would take over from the Attorney General to actually enforce the regulation. So I think, like California will get there because they've got this agency that's going to take over. But China, I think we can expect to be a strong enforcer pretty much from the beginning, although where they'll focus is what we have yet to really see.
A few other quick questions that I think we can briefly cover. Is business to business data covered by the PIPL? Yes, there's no exception for that. So like under the GDPR, any personal information is covered there. As far as compliance documents, there's a question about will there be any brand new documents that aren't the type of thing the GDPR requires? I would say no, with the slight caveat that again, if you are transferring data to other personal information handlers / controllers or doing international transfers, you're going to have to specifically disclose those parties and their contact info. So it might make sense for you to have kind of a separate link on your website or something that says, hey, here are these people, but it's not technically required to have a separate document. It's just a question of how to implement that. And the last one I think we have time to get to of, is there a requirement to share the personal information protection impact assessment, or PIPA? There is not. There's just a requirement that you keep those reports and keep records of how you're handling data for at least 3 years. So presumably if there's an administrative action, the government could ask, hey, we think you violated this law here, or do you have a papaya, and can you show that you went through the steps and things like that? So it's not something you have to share publicly, and doesn't explicitly say that the government can access them, but the requirement to keep them 3 years clearly envisions that the government could ask for them.
Yeah, and there are some sections of the PIPL that gives the government the authority to investigate and to review documents, to copy documents. So and that was maybe one other thing that I'll just end on is, if anybody's thinking like, oh, China has this new privacy law in place, are we going to see an adequacy decision out of the EU so that we can transfer data, out of the EU into China? Are we going to see them treated differently if we are trying to use the SECs to transfer data into China, but under Schrems we're trying to analyze their legal regime? And I would say generally, at least at this point, I'm going to say the answer is no. There's what is being referred to as a government-sized loophole in the PIPL. This is an example of one, right? If you're doing an investigation, the government has the right under the PIPL to look at, review, and even copy things. And so it's not really clear in the PIPL that that's restricted to just like your reports and your DPIAs. It might also be consumer data. We don't know. And so like as a general rule, this is giving a lot of new rights to individuals, which is, a move in the direction of a strengthened privacy regime. But it's not in any significant way restricting the ability of the government to engage in certain actions. So while it's a big move, it's not one that will get, an adequacy decision coming out of the EU about China. And I think that takes us to the hour. So thank you so much for joining us today. Again, if you do want to learn more about 650's tools, you can go to 650.com/privacy, and that's if you're looking at privacy more generally. If you want to just find out about China, it would be 650.com/China. Thank you so much for your time, and hopefully we'll see you at the next one of these.